Let's get more now on Brexit and the Prime Minister facing growing unrest among Tory MPs deeply unhappy at the threat to undermine Britain's traditional support for the international rule of law. Well, the former Chancellor, Lord Lamont, has said the government's in a terrible mess and backed Lord Howard in saying the UK Internal Market Bill would not get through the Lords in its present form. Well, let's get more now and speak to an associate at the Institute for Government and a leader writer at The Times, Raphael Hogarth. A very warm welcome to the programme. Given the international condemnation and indeed criticism of this draft bill from within the Conservative Party and a number of grandees, the fact that it may not go through the Lords, will that be the end of it?
Well, I think that's the crucial question. I mean, I wouldn't expect this bill to get past the Lords unamended. It may not even get past the Commons unamended. But I think really the crunch point with this is going to come when the government has to decide how it responds to any amendments that are passed by the Commons or the Lords, or indeed that are tabled. I mean, if the Lords amends this bill, it then gets kicked back to the Commons, and the government will have to decide: is it going to back down and accept that the importance of compliance with the international rule of law is such that it can back away from the powers that it's tried to take here, or is it going to insist on its view that it needs the powers to set the UK's future state aid regime in respect of Northern Ireland and customs procedures for Northern Ireland, Great Britain trade, irrespective of what it's agreed in the withdrawal agreement?
So there's going to be a bit of ping-ponging, you suspect, but the EU threatening legal action if the bill does go through. UK government, all the signs are that they're not planning on backing down. They believe that their sovereignty overrides, or as you might put it, trumps any international treaties.
Yes, I mean, what the EU has said is effectively that the UK has until the end of the month to sort this out. I mean, we have to take a step back and have a bit of perspective. This is a bill that's been brought to Parliament, but it's not yet law. And there are quite a lot of people who suspect that it's not going to become law. So the EU has said, right, well, this is a breach of the sort of good faith obligations under the withdrawal agreement already, because that agreement said don't take any measures which might jeopardise the effective implementation of this. But the actual sort of offending powers are not in law yet and certainly haven't been used yet. I mean, you're absolutely right to say that the UK's sort of argument here, the argument that was put forward by the Attorney General yesterday, is that it's perfectly free to table this legislation in Parliament because Parliament is sovereign and Parliament can make any law that it wants to make. Now, that's absolutely true as far as it goes, and what it means is that sort of no other institution within the UK, least of all the courts, can step in and stop Parliament from making that legislation. But what that doesn't speak to is whether at the end of the day that's legal and international law. Parliament can do it without being stopped by the courts, but that doesn't mean that it's legal and international law, and that doesn't mean that it will be found to be lawful if the UK is in the end taken to the European Court of Justice over this.
Kay Burley this morning was speaking to a minister from the government who said there's precedent for this, that the Germans have taken on the European Central Bank when they think it is called into question their sovereignty and think they're well within their rights to do this.
I think the government's arguments on precedent for this are extraordinarily unpersuasive. What the government is trying to do with this legislation is explicitly override a treaty that it's just agreed to. Now, there have been examples in the past, both in the UK and in other EU member states, where domestic legislation has come into conflict with EU law and international law. The key difference is that in the past and in other jurisdictions, the stated objective of the member state is to bring itself into compliance and to argue in the first instance why it is in compliance. And that's an important distinction, because what a state does when it says that is we disagree with you about what the law is, but we are absolutely determined to make sure we comply with the law, whatever it is. What the UK has done here is qualitatively different from that, because it's not making an argument about why it is acting lawfully. It's saying we're acting unlawfully and we don't care. And that's why it's engendered quite stark reactions from a lot of European partners and other partners around the world.
Okay, so much more I could ask you about that, but I'm afraid we are out of time. Raphael Hogarth from the Institute of Government, really good to get your thoughts. Thank you.